11. The Constitution for the United States. A. Its sources and its application. Proposed by Congress September 5, 1794. Proclaimed adopted January 8, 1798. 164. This amendment was proclaimed as adopted on January 8, 1798 following suit by a claimant in South Carolina against the state of Georgia, decided in 1793. Many of the states were under heavy financial embarrassment when the Union was formed, and the case of Chisholm against Georgia excited much alarm. Although a resolution proposing an amendment was offered in Congress 2 days after the decision was. Amendment Articles 11, 23. The judicial power of the United States shall not be construed to extend to any suit in law or equity, commenced or prosecuted against one of the United States by citizens of another state, or by citizens or subjects of any foreign state. 164. Announced. The 11th Amendment did not become a part of the Constitution for almost 5 years. The Australian Constitution expressly grants jurisdiction to the High Court where a citizen desires to sue a state. Proposed by Congress December 12, 1803, proclaimed adopted September 25, 1804. 165. The chief difference 76, 77, 78, 79 between this amendment and the language which it superseded is that the elector votes for a named individual for president and another for vice president. Under the old provision the elector voted for 2 persons, without designating either for either office. The person having the greatest number of votes became president, and the one receiving next to the highest number became vice president, notwithstanding that, as in the case of Jefferson, he might be an intense disbeliever in the President Adams's political opinions. When, at the next election, Jefferson and Burr received the same number of electoral votes, and the election therefore was thrown into the House of Representatives, where 35 ballots were taken before the choice of first place fell to Jefferson, the second place thereby going to Burr, the people became convinced that a change in the electoral machinery was necessary. Now, under this amendment, the electors name in their ballots the person voted for as president, and in distinct ballots the person voted for as vice president. When the election of a president is now thrown into the House of Representatives, that body makes choice from the persons having the highest numbers, not exceeding 3 on the list of those voted for, before the choice was made, from the 5 highest on the list. Since the passage of the 20th Amendment 188, it is required that the electors meet on the first Monday after the second Wednesday in December following elections to cast their votes. Article 12. The electors shall meet in their respective states and vote by ballot for president and vice president, one of whom, at least, shall not be an inhabitant of the same state with themselves. They shall name in their ballots the person voted for as president, and in distinct ballots the person voted for as vice president, and they shall make distinct lists of all persons voted for as president, and of all persons voted for as vice president, and of the number of votes for each, which lists they shall sign and certify, and transmit sealed to the seat of the government of the United States, directed to the President of the Senate. 165. The President of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates, and the votes shall then be counted. 166. The person having the greatest number of votes for president shall be the president, if such number be a majority of the whole number of electors appointed, and if no person have such majority, then from the persons having the highest numbers not exceeding 3 on the list of those voted for as. 166. A controversy which threatened the peace of the country arose in 1876 respecting the electoral vote for Rutherford B. Hayes, the Republican candidate for the presidency, and that cast for Samuel J. Tilden, the nominee of the Democratic Party. In Louisiana 2 electoral returns were made under rivals claiming to be governor. The legality of the returns made in some other states to the President of the Senate also was questioned. The claim was made that the President of the Senate, who was then a Republican, should, under this clause, do the counting. On many points the disagreement between the partisans was so wide and apparently so hopeless that it was finally determined to leave all questions to an electoral commission to be created by act of Congress and to consist of 5 members of the Senate, 5 members of the House and 5 justices of the Supreme Court. That commission, after an extended hearing of evidence and argument, found by a strictly partisan vote, that 185 electoral votes belonged to Hayes and 184 to Tilden. To prevent the recurrence of some of the questions, Congress passed the Electoral Count Act of February 3, 1887, providing 1. That if there has been in a state a final determination of any electoral controversy, the governor shall certify the decision to the Secretary of State, who shall transmit the information to the first meeting of Congress. 2. That if more than one return of vote should be made by a state to the President of the Senate, that one shall be counted which was delivered by the regular electors. 3. That when the question is which of two election boards in a state is regular, that one will be recognized which the Senate and the House decide to be the one authorized by law. 4. But if the Houses disagree, then the electors certified by the governor of the state shall be accepted. 5. That Congress shall sit in joint session in the House of Representatives at 1 o'clock in the afternoon of the second Wednesday in February following the meeting of electors. 6. That there shall be 2 tellers for the Senate and 2 for the House, who shall receive from the President of the Senate the election returns from each state as he opens them in alphabetical order, and who shall read the returns in the hearing of the joint session and make lists of the results and give them to the President of the Senate for announcement. 7. And that the President of the Senate shall call for objections in writing of any state for consideration by each House. Since the passage of the 20th Amendment 188, Congress meets on January 6 after the presidential election, to receive the votes of the Electoral College. President. The House of Representatives shall choose immediately, by ballot, the President. But in choosing the President the votes shall be taken by states, the representation from each state having 1 vote. A quorum for this purpose shall consist of a member or members from 2/3 of the states, and a majority of all the states shall be necessary to a choice. And if the House of Representatives shall not choose a President whenever the right of choice shall devolve upon them, before the 4th day of March next following, then the Vice President shall act as President, as in the case of the death or other constitutional disability of the President. The person having the greatest number of votes as Vice President, shall be the Vice President, if such number be a majority of the whole number of electors appointed, and if no person have a majority, then from the 2 highest numbers on the list, the Senate shall choose the Vice President. A quorum for the purpose shall consist of 2/3 of the whole number of senators, and a majority of the whole number shall be necessary to a choice. But no person constitutionally ineligible to the office of President shall be eligible to that of Vice President of the United States. It has been pointed out that the first 11 amendments sprang from the fear of national power which many of the states possessed. Those amendments were designed to stay the national hand. Amendment 12 was procedural to eliminate confusion in the selection of the President and Vice President and in definition of their succession in the implementation of their duties under the Constitution. Ratified March 12, 1819. The founders held an intense disdain and distrust of nobility, as a result of a long history, during colonial times, of abuses and excesses against the rights of man and the established common law and constitutions by the nobility, and therefore placed in the new Constitution 2 injunctions against acceptance of titles of nobility or honor or emoluments from external sources. The Revolutionary War for Independence was primarily waged to eliminate these abuses and excesses of the nobility and the moneyed classes from the life of the nation, recognizing the equality of all men. As there was no penalty attached to a title of nobility or honor in the Constitution as originally ratified, the original 13th Amendment was proposed in December of 1809 to institute penalty for accepting or using a title of nobility or honor, to set oneself apart from, or superior to, or possessing of any special privileges or immunities not available to any other citizen of the United States, and to eliminate the widespread. The original 13th Amendment use of emoluments as bribery and graft of the legislatures and judiciary used to further the causes and positions of special interests. It was an attempt to keep politicians and civil servants honest in their service to the citizens. As noted in the discussion 69 in Article 1 of the Constitution, the original 13th Amendment was ratified in 1819, adding a heavy penalty upon any person holding or accepting a title of nobility or honor, or emoluments from external powers by making that person cease to be a citizen of the United States, and incapable of holding any office of trust or profit under the United States. This amendment was proposed, properly ratified, and was a matter of record in the several states' archives until 1876, by which time it was quietly and fraudulently deleted, never repealed, during the period of Reconstruction after the Civil War, and the presently acknowledged 13th Amendment was substituted. The original records of the original 13th Amendment were thought to be destroyed at the time of the burning of the Capitol during the War of 1812, but have since been found in the archives of the British Museum, the National Archives, and in the archives of several of the states and territories. The fact of its existence had been lost to memory until, by chance, researchers discovered in the public library at Belfast, Maine, an 1825 copy of the U.S. Constitution. Ma 1825. Subsequent research shows that it was in the records of the ratifying states and territories until 1876. The last to drop it from record was the territory of Wyoming after 1876. The most intriguing discovery was the 1867 Colorado Territory edition, which includes both the missing 13th Amendment and the current 13th Amendment on the same page. The current 13th Amendment is listed as the 14th Amendment in the 1867 Colorado edition. See images Colorado 18681, CO 18682, CO 18683, CO 18684, and CO 1868-5. The 1876 laws of Wyoming, which similarly show the missing 13th Amendment, the current 13th Amendment freeing the slaves, and the current 15th Amendment on the same page. The current 13th Amendment is listed as the 14th, the current 14th Amendment is omitted, and the current 15th Amendment is in proper place. See images WA 18761, WY 18762, WY 18763. See Ref. 13th Amendment Publication Table. For further discussion and the history of the original 13th Amendment, see Demon of Discord, Ratification and Suppression of the original 13th Article of Amendment to the Constitution of the United States. On December 3, 1860, the month after Lincoln was elected president, Buchanan asked Congress to propose an explanatory amendment. It was to be another 13th Amendment, to eradicate and cover up the deletion of the original 13th Title of Nobility and Honor Amendment. This proposed amendment, which would have forever legalized slavery, was signed by President Buchanan the day before Lincoln took office. 167A. This amendment to the Constitution relating to slavery was sent to the states for ratification by the second session of the 36th Congress on March 2, 1861, when it passed the Senate, having previously passed the House on February 28, 1861. It is interesting to note in this connection that this and the ratified Anti-Slavery Amendment of 1865 are the only resolutions proposing amendments to the Constitution to have been signed by the President. The President's signature is considered unnecessary because of the constitutional provision that on the concurrence of 2/3 of both houses of Congress the proposal shall be submitted to the states for ratification. The resolve to amend signed by President Buchanan on March 2, 1861, 2 days before Lincoln's inauguration, read: Resolved by the Senate and House of Representatives of the United States of America in Congress assembled, that the following article be proposed to the legislatures of the several states as an amendment to the Constitution of the United States, which, when ratified by 3/4 of said legislatures, shall be valid, to all intents and purposes, as part of the said Constitution, viz. Article 13. No amendment shall be made to the Constitution which will authorize or give to Congress the power to abolish or interfere, within any state, with the domestic institutions thereof, including that of persons held to labor or service by the laws of said state. In other words, President Buchanan had signed a resolve that would have forever permitted slavery, and upheld states' rights. Only one state, Illinois, Lincoln's home state, had ratified this proposed amendment before the Civil War broke out in 1861. It appears at 12 Stat. 251, 36th Congress. 2 more state legislatures ratified it, beginning with Ohio on May 13, 1861, followed by Maryland on January 10, 1862. But the onslaught of the Civil War taught that the nation may be in even greater peril from the states than they ever were from the nation. And so, after more than 70 years of national life, the people, by the presently acknowledged 13th Amendment and the two following, laid upon the states restrictions which a few years before would have been impossible. The Constitution had gone 46 years, 1819-1865, without an amendment. See 41. In the tumult of 1865, the original 13th Amendment was removed from our Constitution. In a congressional resolve to amend dated December 5, 1864, approved and signed by President Lincoln, February 1, 1865, another amendment numbered 13 which prohibited slavery in Sect 1, and ended states' rights in Sect 2, was proposed. When, on January 13, 1865, a two-thirds vote was taken in the House of Representatives for proposing the currently presented 13th Amendment, in honor of the immortal and sublime event, the House adjourned. It was then presented to the states for ratification. 2 months later, April 9, 1865, the Civil War ended with General Lee's surrender. On April 14, President Lincoln was assassinated, dying on April 15. Proposed by Congress February 1, 1865, proclaimed adopted December 18. 1865.168. See also Utah Supreme Court Opinion, Diet v. Turner, a March 22, 1968 opinion of the Utah Supreme Court. It is the official view of the court on the flawed nature of the so-called 13th and 14th Amendments. On December 18, 1865, the new 13th Amendment loudly prohibiting and abolishing slavery and quietly surrendering states' rights to the federal government was proclaimed adopted by Secretary of State Seward, replacing and effectively erasing the original 13th Amendment that had prohibited acceptance of titles of nobility and honors and emoluments, and dishonest politicians have been bought and bribed and have treasonously accepted graft from external sources ever since, with no thought of penalty. 168. The language of this amendment is older than the Constitution itself. On July 13, 1787, the Congress under the Articles of Confederation passed the ordinance creating the Northwest Territory, Ohio, Illinois, Indiana, Michigan, and Wisconsin, which provided, "There shall be neither slavery nor involuntary servitude in the said territory otherwise than in punishment of crimes, whereof the party shall have been duly convicted." But a proviso required the return from the territory of fugitive slaves. When, on January 13, 1865, a two-thirds vote was taken in the House of Representatives for proposing the 13th Amendment, in honor of the immortal and sublime event, the House adjourned. Congress had previously abolished slavery in the District of Columbia and in the territories, had repealed the fugitive slave law, and had given freedom to the Negroes who had served in the Union armies. The Emancipation Proclamation freed the slaves only in the seceded states, excepting some parishes, counties in Louisiana, a few counties in Virginia, and the whole of Tennessee. Besides, the validity of the proclamation under the war power of the President was questioned. To remove the legal doubt and to liberate slaves everywhere, the amendment was adopted. Article 13, Section 1. Neither slavery nor involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall exist within the United States, or any place subject to their jurisdiction. 170. 170 Congress passed under this constitutional authority the Civil Rights Act of March 1, 1875, another act prohibiting peonage, and some other statutes. The first and second sections of the Civil Rights Act of Congress were held, 1888, by the Supreme Court in contravention of this amendment, which is a regulation of the states with regard to slavery, and which does not authorize Congress to regulate the conduct of individuals who prevent Negroes from having the full and equal enjoyment of hotels, theaters, and other public places. Legislation of this kind comes within the police power of the state. In many of the states there has been legislation requiring the providing of separate but equal accommodations for white persons and Negroes. Such regulations have been held valid as essential to public order. See 18. The Supreme Court has said that while the object of this amendment was undoubtedly to enforce the absolute equality of the two races before the law, in the nature of things it could not have been intended to abolish. Of the 13th Amendment, a federal court said, "It trenches directly upon the power of the states and of the people of the states. It is the first and only instance of a change of this character in the organic law. It destroyed the most important relation between capital and labor in all the states where slavery existed. It affected deeply the fortunes of a large portion of their people. It struck out of existence millions of property. The measure was the consequence of a strife of opinions, and a conflict of interests, real or imaginary, as old as the Constitution itself. These elements of discord grew in intensity. Their violence was increased by the throes and convulsions of a civil war. The impetuous vortex finally swallowed up the evil, and with it forever the power to restore it." See 110. A law of a state under which one fined for a misdemeanor confessed judgment and agreed to work out the fine for the surety who paid it for him was held by the Supreme Court, 1914, to be unconstitutional as creating involuntary servitude, in violation of this amendment. See 110. A person who hired another under a contract by which the hirer had the right to imprison the worker or keep him under guard until the contract should he performed was held, 1903, by a federal court to violate the Peonage Act of Congress, 1867, passed under this amendment. And so it was held, 1907, of a state law making it a misdemeanor punishable by imprisonment for one to agree to perform service and then, after receiving a part of the consideration in advance, refuse to perform. See 110. Thus it is seen from very late cases that this provision is still vital and active. But in many cases it has been held that city ordinances requiring persons committed to the city prison to work out their fines in the streets or elsewhere do not violate this amendment. See 110, Section 2. Congress shall have power to enforce this article by appropriate legislation. Proposed by Congress June 16, 1866. Proclaimed adopted July 21, 1868. 171. See also Utah Supreme Court Opinion, Diet v. Turner, a March 22, 1968 opinion of the Utah Supreme Court. It is the official view of the court on the flawed nature of the so-called 13th and 14th Amendments. Distinctions based upon color, or to enforce social, as distinguished from political equality, or a commingling of the two races upon terms unsatisfactory to either. The court said that laws permitting and even requiring separation did not imply the inferiority of either race to the other, and such laws had been generally, if not universally, recognized as within the competency of state legislatures in the exercise of their police powers. 171. The 13th Amendment was found to be not enough. Reviewing the history of the times, the Supreme Court pointed out that in some states the former slaves were forbidden to appear in the towns in any other character than menial servants, that they were required to reside upon and cultivate the land, without the right to purchase or own it, that they were excluded from many occupations of gain and were not permitted to give testimony in the courts in any case where a white man was a party, that laws were passed imposing heavy fines on vagrants and loiterers, who, if unable to pay the fines, were sold to the highest bidder. These circumstances, said the Supreme Court, whatever of falsehood or misconception may have been mingled with their presentation, forced upon the statesmen who had conducted the federal government in safety through the crisis of the rebellion and who supposed that by the 13th article of amendment they had secured the result of their labors, the conviction that something more was necessary in the way of constitutional protection to the unfortunate race who had suffered so much. See 51. Hence the 14th Amendment. This amendment made the Negro not only a citizen of the United States but also of the state of his residence. It struck the word white from the constitutions of northern states which had limited citizenship to white males. In North and South the Negro became possessed in law of all the rights of citizenship. See 17. The citizen was not, under the theory of states' rights, in contact with the national government. He owed allegiance to his state, and the state dealt. Article 14, Section 1. All persons born or naturalized in the United States, and subject to the jurisdiction thereof, are citizens of the United States and of the state wherein they reside. With the nation. That theory was definitely set aside by this amendment, which made all persons born or naturalized in the United States and subject to the jurisdiction thereof citizens of both the nation and the state, owing allegiance to both authorities. James Wilson of Pennsylvania stated 19 this doctrine clearly in the Constitutional Convention. The contention was made in the first great case to arise under this amendment, which did not involve the Negro at all, the controversy being between rival business houses, that the amendment originated a new citizenship for all, which supplanted former state citizenship and changed the rights attending it. That would mean that the national government would now be the source of all those rights of a fundamental character which belong to the citizens of all free governments by virtue of their manhood, and for the protection, not creation, of which all just governments are formed. The Supreme Court rejected, 1873, the contention and said that the amendment did not disclose any purpose to destroy the main features of the general system. It held that the command that no state shall abridge the privileges or immunities of citizens of the United States does not prevent a state from abridging privileges of state citizenship as distinguished from privileges of national citizenship. This momentous decision, involving the preservation of state citizenship and state rights, was, like that upholding the power of the President in the Civil War to blockade ports and take any steps necessary to preserve the life of the nation, rendered by a majority of one vote. In the Dred Scott case 1856 brought by a Negro servant of a surgeon in the United States Army, who had been taken into Illinois and other free territory and who claimed for that reason the right to liberty, as the Negro slave Somerset had by the decision of Lord Mansfield been liberated when he was taken from Virginia to England, the Supreme Court held that the Negro was not intended to be included under the word citizen in the Constitution, for which reason he had no standing in court. By this amendment he became a citizen of the nation and a citizen of his state, and possessed of the benefits of all state and national constitutions and laws. The Fugitive Slave Provision 121 was inserted in the Constitution to prevent the application in this country of the rule announced in the Somerset case. XI-XXIII, C-51. While the 14th Amendment was intended primarily for the benefit of the Negro race, said a federal court, it also confers the right of citizenship upon persons of all other races, born or naturalized in the United States. But a person born in the United States and not subject to the jurisdiction thereof does not become a citizen, such as the child of a foreign minister or consul. C-51. The refusal of Congress to permit the naturalization of Chinese was held by the Supreme Court 1898 not to exclude from the benefit of this amendment a Chinese born in the United States and subject to the jurisdiction thereof. While the parents were subjects of the Emperor of China, they were permanently domiciled in the United States and carrying on business. The definition of citizen in this amendment is only an affirmation of the ancient rule of citizenship by birth within the territory. Google to read more.